Okay, so today we are going to look at examination of witnesses. Now, the examination of witnesses in criminal trials are very, very important. You understand? So, where a criminal trial is in court, the prosecution ordinarily we have to adduce evidence. You understand? With the purpose of ensuring the conviction of the accused, and then the defense counsel, on the other hand, will also adduce evidence with the purpose of obtaining the discharge and acquittal of his clients. You understand? So one of the way they can adduce evidence is to call witnesses. You understand? Witnesses are very, very important, especially material witnesses. So witnesses are very, very important in criminal trials. So now, when witnesses come to court, when witnesses are called, whether they were called originally or they were subpoenaed, you understand? They don't just come to court and then start saying, immediately the trial starts, they will start saying, my lord, on that day I saw Okafor, he was the one who committed the offense. No, they don't do that, understand? There are stages of examination of witnesses, you understand? There are procedures involved in the examination of witnesses. And then if that witness is also coming to tender a document, a witness might be called for the purpose of tendering a document. It could be a video recording or whatever medical report, an autopsy report, any medical document, any document at all. A witness might also be called to tender a document. Now, the witness does not just come and say, my lord, look at the medical report showing that this girl was actually raped by the defendant. I'm the doctor that prepared. It's not done that way. There are procedures. You understand? Everything is everything is procedural. You understand? Everything is procedural. Everything is procedural. There are procedures to do that. There are procedures to examine witnesses. So when witnesses are called to court, they are examined, and there are three stages of examination of a witness. There are three stages. We have the examination in chief, which occurs first. Now, a witness is examined in chief by the party who called him. You understand? By, let me say, for instance, the prosecution. I will use the prosecution as an example because in criminal trials, it is the prosecution that starts first. You understand? So examination in chief is done first by that party who called the witness. So the prosecution starts his case first. He opens his case first. You understand? So the first thing the prosecution does is to, after he has done his opening address, he has addressed the court. This is the case. This is the evidence we are used. These are witnesses we will call. The next thing he does is to call any of those witnesses and then conduct examination in chief on that witness. And then after he's done examining that witness in chief, then with the second stage will now be cross-examination. Now, cross-examination is done by the opposition party. You understand? So if the prosecution called the witness and then he has examined that witness in chief, that witness now will now be cross-examined by the defense counsel. You understand? The purpose of cross-examination is usually to render unreliable the evidence that witness has given for the prosecution. So the defense counsel will want to, show contradictions and inconsistencies in the evidence of that witness. Understand? And then after that, what we have is re-examination. Now, re-examination is done in this case by the prosecution under his witness again. You understand? Re-examination is now done by the prosecution under his witness again. So re-examination is just like examination in chief, is done by that party who called the witness. You understand? So a re-examination has two major functions: to clarify any inconsistencies that may have arisen, and to resolve ambiguities raised. You understand? Any ambiguity that was raised during cross-examination or any inconsistency that was pointed out in the cross-examination. Now, the re-examination is an opportunity for the prosecution, you understand, to resolve such inconsistencies and ambiguities. Now, let me give you a practical example. If you're explaining these things like this, you might not really understand perfectly. Now, imagine a situation whereby you were in the university and then later on you got admission to the Nigerian Law School, Lagos campus, for instance. And then you have a friend from your university, like your coursemate and your friend, you understand? So the both of you are in Lagos campus, but the both of you are not roommates, you understand? And then you have a roommate, and then that your roommate is very troublesome, you understand? The roommate always gives you a problem. The roommate is very troublesome. And then one day, your coursemate from the university, that is who is also at the Lagos campus with you, let me say her name is Bukola, you understand? Bukola comes to visit you in your room. Bukola comes to visit in your room, and then a fight broke out between you and that your roommate. Understand? A fight broke out between you and that your roommate, and then your roommate broke your head. Committed assault, criminal assault or as we call it, battery against you, and then that your roommate broke your head. And then maybe Bukola was capturing everything with her phone, like a kind of photograph or pictures in her phone, and then the matter gets to court. You understand? The matter gets to court. You have charged her to court. You have set the law in motion against her for criminal assault. You understand? And occasioning grievous bodily harm. Ordinarily you call your friend. You understand? Your material witness will be that your friend. You understand? Your material witness will be Bukola. That's your friend, because she was there. She was present in court. You understand? But then now, Bukola will not just come to court and start saying, "My lord, I was there. I saw when the fight broke out. This girl injured my friend." There's a procedure. You understand? So the first thing that is going to happen now is what we call examination in chief. You understand? So the prosecution will call Bukola. You understand? And then Bukola will go to the witness box. You understand? Maybe they will have to. She will have to swear an oath. Oftentimes, witnesses swear an oath that they will say nothing but the truth. You understand? And then the examination in chief will commence after the swearing or the affirmation or oath. After the swearing or the affirmation, then the examination in chief is going to commence. Now, look at just see how the examination in chief usually looks like. The prosecution will be like, "Witness, tell the court your name, your address, and what you do for a living." And then Bukola will be like, "My name is Bukola Adeyemi. I'm a student of the Nigerian Law School Lagos campus." She will just introduce herself. And then the prosecution will be like, "Can you tell the court what happened on the 15th day of August 2025? You understand? And then Bukola will be like, "On that day at the Nigerian Law School Lagos campus, I went to see my friend." And then in getting there, we were gisting. All of a sudden, a fight broke out between my friend and her roommate, leading to the grievous bodily harm which my friend occasioned as a result of the harm caused by her roommate. You understand? And then maybe the witness would be like, and then you recorded it, right? You made a video. You took some pictures. You took some pictures of the incident, right? And then Bukola will say yes. You say just of necessity. Bukola will agree. We say yes. I took some photograph of the incident that day. You understand? And then the prosecution counsel will not stop there. You understand? The prosecution counsel we proceed, to ask some questions which forms part of the foundation in order for that photograph to be admissible. Now the prosecution can go on and say, Bukola, please, the phone in question that you use to capture this photograph, have such a phone been put into regular use other than for that particular day? Bukola will say, yes, of course. The phone has been used, you understand, over time. And then the prosecution might go again. Please, at that time you recorded at that time you took that photograph, was the phone properly functioning? You understand? Was it properly functioning? And then Bukola will say, yes, of course. The phone did not have any issue. It was properly functioning. You understand? It was properly functioning. So when the prosecution puts one or two questions across, he can just finish up with that witness. So if you look at this scenario that I painted for this examination in chief, you will notice that four things have been done. You understand? Four things have been done in this scenario. You understand? Four things have been done in this scenario, which is fundamentally the purpose of examination in chief. So, for instance, we have introduced undisputed facts. You understand? Such as the fact that Bukola was there on that day, such as the fact that indeed there was a fight between Bukola's friend and her roommate. And then we have also stated a case for the party. For instance, I'm the prosecution counsel. I've helped in stating a case, that I've presented a case in favor of the nominal complainant or victim. And then we have also laid foundation for the tendering of exhibits, although we'll get to that very much properly later. But, for the fact that I, as a prosecution counsel, was asking Bukola if, that document Bukola wants to, that document that wants to be tendered through Bukola is a computer-generated evidence, because it's a photograph that was taken by a phone. And then if you look at Section 84, Sub 2 of the Evidence Act, it provides for conditions for the admissibility of computer-generated evidence. So that thing I was trying to do is what we call laying foundation. I was asking her, was the phone properly functioning at the time she was taking the picture? Has the phone been put into regular use? You understand? other than that particular day that which the said picture was taken. You understand? That kind of stuff. So I was laying foundation. I was fulfilling the conditions stated in section 84 sub 2, so that the court is going to accept that photograph as being genuine. You understand? And then I was also presenting favorable evidence. I was also presenting favorable evidence for the nominal complainant or the victim, for the nominal complainant or the victim. So I want you to know that apart from this examination in chief, it's not the end. You understand? They won't just tell Bukola will not be allowed to go. You understand? Unless maybe there are other witnesses that want to also testify for the prosecution. So after this, there is usually what we call cross-examination. Now the defendant counsel is the one who is going to cross-examine Bukola. You understand? Now the purpose of cross-examination is usually to neutralize the effect of the evidence given by Bukola, to show that Bukola has probably made an inconsistent statement, or to show that Bukola's evidence is not credible, or to show that Bukola is not a trustworthy witness. You understand? So the essence of cross-examination is to batter, is to defeat, is to destroy the evidence that was adduced during examination in chief. Now, a cross-examination might go something like this. Now, this is the defense counsel now questioning Bukola. He say, Miss Bukola, please, what particular time did you arrive at the room on that day? And then Bukola will be like, I arrived around 8 a.m. And then the lawyer will be like, for Bukola, in the proof of evidence, it was stated that the fight occurred around 1 and you arrived around 12. And the Bukola will be like, yes. I think I came twice. I came twice that day. I came around 8 in the morning first. I didn't know the exact one you were asking me of. I came around 8 o'clock. I also came around 12 before the fight broke out. And then the defense counsel will come again. Will be like, Bukola, you said you recorded this incident, and you saw my client breaking the head of your friend, and you are sure it was my client. You understand? How do we know that this? How do we know that this photograph that was tendered is not in any way altered, is not in any way fabricated? I'm asking you this because there are evidence to show, or you say, I put it to you that on that particular day in which this alleged photograph were actually snapped by you, that on that particular day you also told your friend that your phone was bad. In fact, your phone was irredeemably bad, that it could not do anything. So how come the same phone also took this photograph, Bukola? You understand? So the lawyer is trying to put Bukola in tight position. You understand? He's trying to put Bukola in a very tight, tense position. Oftentimes, cross-examinations are confrontational. You understand? You see the witness sweating, shaking, or you see that the lawyer and the witness are arguing. You understand? In the cross-examination. So after the cross-examination, after all this hula baloo and the holy bollies and all that, now the prosecution will usually call back Bukola. Now this is what we refer as re-examination. Now the prosecution will then call back Bukola, and re-examine Bukola. Now the purpose of re-examination, like I said before, is to resolve inconsistencies, to clarify ambiguities that may have arisen from the cross-examination. Now, how is this done? The prosecution might now put some questions across to Bukola again. Bukola, please, can you remember that on that particular day, you said, yes, your phone was bad, but it was not bad to the extent that you could not take pictures. You understand? Then Bukola will say, yes, my phone is bad, but not so bad. I can turn it on, and then for let me say, after 4 minutes, it's going to turn off automatically. It's not like it was absolutely bad. I didn't mean, on that day, I did not mean irredeemably bad, as though the phone could not turn on at least. You understand? So the purpose of re-examination now is to clarify inconsistencies, to make the evidence of that witness believable again. If the court is seeing some doubt, to make the evidence believable again in the eyes of the court. You understand? To make it believable again. So these are mainly the 3 stages of examination of a witness. Now, I want you to know that this goes hand in hand. You understand? So it's not only prosecution witness that it goes hand in hand. It goes hand in hand. Prosecution can also cross-examine defense with, because even the defense, after the prosecution has finished, then the defense will come his own, make his opening address, call his own witnesses. So the same procedure that was taken in this case will also be applied against the defendant's witnesses. You understand? So now we now go to these very important. Now I want to look at these stages properly and look at the core issues that arise in these stages. Now one of them is now we want to look at examination in chief properly, deeply, and more practically. Like I told you, one of the things that occur in examination in chief is to lay foundation for exhibits. You understand? You lay foundation for the tendering of exhibits. Now this is very, very important. Like I told you before, when a witness has a document to tender that is important to you, for instance, you, the prosecution, is important to you, the witness will not just come to court and tell the court, I have a document. Yes, I have it. It's in my pocket. Yeah, look at it, my lord. That was the document. By this document, it shows that the defendant is guilty. No, it's not done like that. You understand? Foundation must be laid. Foundation must be laid. Foundation must be laid. Now, laying foundation is fulfilling any necessary condition for the admissibility of that particular document. Now, there are two ways in which foundation may be laid. You understand? Now, some legislations, some laws, some statutes have provided for, some laws, some legislation has provided for conditions that must be fulfilled. You understand? Either statutory law or case laws or whatever. They have established conditions. You understand? They have established conditions that certain documents must fulfill before they can be admitted. You understand? So when you fulfill those conditions, then you have laid foundation for the admissibility of that document. Remember, when we were doing is it pre-trial investigation, when someone makes a statement and then an interpreter was used, the proper, like there are certain conditions that must be fulfilled before that document can be admitted. You understand? For instance, both the person who recorded the statement and the interpreter must be present in court. You understand? So in that case, now as a prosecution, you say, my lord, look at you identify maybe the recorder is there who is the witness. You say, I'm the recorder, I recorded it. You understand? I recorded it, and this person is interpreter. He is the one who interpreted it. And then both the interpreted version and the original version will also be tendered. You understand? So this is an example of laying foundation. Another example of laying foundation is with respect to computer-generated evidence under Section 84. So you saw that, like in the example I gave you in Bukola, I was doing it orally. You understand? Although, when it comes to computer-generated evidence under Section 84 sub 2, there are two ways you can lay foundation. You can either do it by the certificate of authenticity. That certificate is more like an affidavit. You understand? In that certificate, which is more like an affidavit, you'll be seeing statements like that the phone that was used to record this video was properly functioning at the time it was put into regular use. The information contained is of the same nature and kind. So it will just show that document. You might just carry that document and tender before the court. Now the court will look at that document and see that the phone that was used in capturing the incident, complied with, was properly functioning and all that. It's just to show that Section 84 sub 2 has been complied with. And then you can also choose to do it orally. You understand? You can also choose to do it orally, like I was doing in the case of Bukola, whom I called as a witness. I was asking her if the phone was properly functioning at the time in which she snapped those pictures. You understand? If the phone was put into regular use, if the information contained in the picture is of the same nature and kind, regularly fed into that same phone. You understand? So she will not just answer yes or no. If she also has any other relevant statement to make, she can also make as well. You understand? So in that case, we are following the statutory pattern of laying foundation. So like I said before, some statutes, some legislation has provided for ways. They have stated some conditions for the admissibility of certain documents. And then now there are some areas of law that there is no legislation. There is no law providing any condition precedent. There is no law similar to Section 84 sub 2 of the Evidence Act on that particular issue. So now you ask yourself, how do you lay foundation? Now, in this case, you lay foundation simply by putting questions across to the witness. You understand? You can just lay your foundation using the normal question and answer method. You understand? You just lay foundation using the normal question and answer method, and then in that your question and answer method, you show, you show and establish certain things. You show and establish certain things. Now let us give an example. Let us give an example. Mm, Now let us imagine a situation whereby someone is charged for the offense of murder. Someone is charged for the offense of murder. Let us give an example whereby someone is charged for the offense of murder. And then me as a prosecution, I call the medical doctor. I call the medical doctor. I called a medical doctor, and the medical doctor conducted an autopsy. He carried out an autopsy on the corpse, and then to ascertain what caused death and all that. And then after everything, he prepared an autopsy report. You understand? And then I want to tender that autopsy report in court. I want to tender that autopsy report in court. Now there is no law. There is no law. For instance, now there is no legislation saying before an autopsy report to be admitted, this one must be stated. It must be this. It must be that. I'm just saying, like, there's no law like Section 84 sub 2 now in this case. Now, how do I now? What conditions am I going to fulfill? How do I now tender this a document? You understand? What would be my guide? So now, in this case, we'll just use the normal question and answer method. And the basis of this laying foundation is for us, is for the court to know if at all that medical report was prepared by that medical doctor called, if he really knew what he was doing. You understand? And if that medical report is indeed credible. You understand? So this is how we lay foundation. The medical doctor steps into the witness box as a witness, and then myself, the prosecution, I'll be like, witness, you made, ordinarily most times for all witness, you start from the question. Instead, they call your name, your address, and where you live, that kind of stuff. That is how they usually start for all witness, usually, you understand? But I'm just trying to limit this because in exam, most times, like if you look at this note now, you just have question A, question B, question C, question D, and question E. Because in exam, most times, what they usually ask is 5 questions. State any 5 questions you put across to your witness to enable him to tender. They say, doc, most times it's 5 questions. I don't know why they like 5 questions. You understand? So when they say 5 questions, you have to remove some and then leave out some. Some are more important. So that was why I just chose this 5. So you can just tell the witness, you made reference to an autopsy report in your analysis. You say yes. And then you say, do you have a copy of it here in court? You say yes. You say, if you see the report, can you identify it? He will say yes. You ask him, how would you identify the said document? He will be like, I prepared the medical report and I also signed it. My signature is there. I will identify it through my signature. You say, okay, fine. Okay, please take a look at this document. Is this the medical report? Is this the autopsy report prepared by you? You understand? Then the registrar, I think so, we usually take some documents and present to him, and then he will identify the particular autopsy report that he prepared. He said, this is the autopsy report. And then after that, the prosecution will then seek the leave of the court to tender that document. Now, foundation has been laid. It's as simple as that. Understand? The prosecution will now say, my lord, I seek to tender the autopsy report, or my lord, I seek leave of the court to tender the autopsy report. Understand? So by this now, the foundation has been laid. Understand? So you might be wondering, like, what was so special here? Why this formality? That is procedural law for you. So that is procedural law for you. You understand? And then where for instance a document is a certified true copy, so to be tendered, and then you are required to show how foundation will be laid by question and answers. Now this method will now be better. Now we're in the second scenario. Now somebody wants to tender a certified true copy. You understand? Somebody wants to tender a certified true copy of a document. How do you lay foundation for that certified true copy? It's also by way of question and answers. You understand? It's also by way of question and answers. So you might be like witness, or maybe you call the witness name. If the witness has already given his name earlier, you say, you can say Mr. Cohn, or you can say witness. You made reference to a certified true copy of the certificate of incorporation. Am I correct? You say yes. And then you say, is there any evidence to show that the said document has been duly certified as a true copy of the original and the prescribed fee paid? You say, yes, I have the receipts here in court. He will answer you. Is the certificate signed, subscribed, and dated by the officer authorized by law to hold the original? You say, yes. Was the said document stamped and sealed? You say, yes. He won't just, most times he won't just say yes. He might just make any further statements that is in consonance with his affirmation. And then, are you with a copy of it here in court? Can you identify it? And please, how would you identify it? You say it has my company logo, blah 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 blah. It's my company. I know the certificate very well. Okay, please take a look at these documents, and they identify the certified true copy. And then he identifies that this is the certified true copy of the say the certificate of incorporation. And then you do the same thing, my lord. We seek the leave of the court to tender the CTC of the certificate of incorporation. So this is how you lay foundation. So if you notice very well, you know that in your civil litigation, I think it's in civil litigation that they taught how to lay foundation for CTC. You must show that document, has been certified. The certificate was subscribed, dated, and signed. It was stamped and sealed. The prescribed fee was paid. So that is exactly what we showed the court. You understand? That is exactly what we did here. Now we just fulfilled those conditions by way of question and answers. You put question across to your witness, he answers, and if he has any further statement or further proof of that, he can also show it to the court. It just goes to make that document credible. To make the document to be credible. It just goes to make the document to be credible. So this is how you tender document. It could also be that the person who made the document is no longer alive, you understand? Or the person is now incapable of giving evidence, or the person has traveled. Ordinarily, it's the person who made the document that ought to tender it. If another person wants to tender it, proper foundation must also be laid. You understand? Question and answers will be asked. Question and answers. Question will be asked, and then answers will be given as to the whereabouts of the maker of the document, where he is, whether a reasonable attempt was made to find him if he was alive, all those kind of things. It's just by way of question and answers, and that is it. So now, if proper foundation was not laid, and then, for instance, prosecution wants to tender a document when proper foundation was not laid. Now, when should the defense counsel raise objection? The answer is simple. He should raise an objection immediately it is sought to be tendered. You understand? He cannot do so on appeal or on the next adjourned date. It is at that time. So imagine if, for instance, a witness is in court, and then they just be like, witness, what happened that day? He said, that day, I was there. I saw everything that happened. I even took pictures. Look at the pictures here. I have a copy of the pictures. My lord, look at the pictures. Look at it. No, that is not how it's done now. Proper foundation has not been laid for the admissibility of that picture. It has not been shown whether the phone or camera that was used to take the pictures was properly functioning. You understand? So in that case now, the defense counsel should just be like, objection, my lord, immediately. You don't need to wait on the next adjourned date. You don't need to wait on appeal. You understand? Immediately. And it is relevant to note that objections are not restricted to examination in chief. Objection may be raised at any time. Objection may be raised during examination in chief. It may be raised during cross-examination. It may be raised. It may be raised at any time, at any stages of examination of a witness at all. You understand? At any time at all, provided the person has not done what is proper. In court scenarios now, you'll be in court. Any small thing objection, my lord. Any small thing objection, my lord. So that is more like it's in consonance with this fact. And then now we ask ourselves: can prosecution call another person other than the witness who prepared, for instance, a report to tender that report in court? Now the law is that the prosecution is not bound to call any specific witness. You understand? The prosecution is not bound to call any specific witness. Prosecution can decide to call 10 witnesses. He can decide to call 1. He can decide to call 5. You understand? And then where, for instance, a particular person prepared a medical report or prepared an autopsy report, and that doctor is no longer available. You understand? There are the law permits that there are instances. The general rule ordinary is that the maker of a document, must be present in court. If you look at Section 83 of the Evidence Act, the maker of a document, that person who prepared it, that doctor who prepared the medical report, must be in court. He must be the witness through whom that document will be tendered. But if, for instance, the maker of the document, the doctor is dead, the doctor cannot be found, is incapable of giving evidence, it could be tendered through another person. You understand? So by virtue of this, the prosecution is not bound. You understand? The prosecution is not bound to call a specific witness. Prosecution is not bound to call a specific witness. You understand? And then we ask ourselves, can the court solely convict on the expert evidence of a witness? Now, if a witness is called and then a witness tenders any medical report or any document, maybe the witness is an expert, like a medical doctor, and then he tenders an autopsy report to show that, yes, this is how the deceased or the victim died. and it was a result of this knife wound or this gunshot or this gunshot wound that killed him. Can the court rely on that evidence alone to convict the defendant? Of course, the court can rely on that evidence alone. You understand? It's an expert evidence, provided the court finds it persuasive. The most important thing about expert evidence is that the court finds that evidence to be persuasive. You understand? The court finds it to be compelling, it's cogent. The evidence is not contradictory. You understand? But the court is not bound by expert evidence. It is within the discretion of the court to accept an expert evidence or not. It's not because a person is an expert and then he has blown one or two medical grammar to the court and then the court will accept it. It is still within the discretion of the court to accept it. You understand? And then we go to the questioning techniques in open questions. Now, what are the questioning techniques in open questions? For instance, when the prosecution has called Bukola is his witness, and Bukola want to give evidence. Now, what kind of questions are allowed and what kind of questions are not allowed in examination in chief? That is what we want to look at now. What kind of questions are allowed? What kind of questions are not allowed? What are the consequences of certain questions? Understand? And then when can certain questions be asked and when can it not be asked? You understand? So one type of question that can be asked in examination in chief is open questions. Open questions. Understand? Now, open questions are questions that allow a witness to describe, explain, or narrate events in their own words. You understand? So when a prosecution be like, a witness, please can you tell the court what happened on the 15th day of August 2025? That is an open question because the witness has all the latitude or freedom to explain, say everything she knows about that particular case. In this case, her expression is not limited. Now, this is an example of what we call open question. You understand? And the importance of open question is that it makes the statement of the witness more believable. It enables the witness to flow without interruption. You understand? It also, for instance, if the witness is an expert, an open question we help that witness, to unravel complexities in that matter to the judge. You understand? For instance, somebody died of what is a pulmonary heart disease, and then the expert is asked an open question in relation thereto. He will have all the freedom to blow all his medical grammar terms, blow all those grammar, tell the court that this is that, So he's not just going to blow the grammar, he's also going to help the court to understand the effect of those their complex medical terms. You understand? He will help the court to understand them by open questions put to him. Understand? Say, can you please help the court understand properly the effect of this virus on the body or the effect of a machete wound on the brain of a person? So in that case, the expert is going to cool down to explain that particular thing. Understand? So open questions can be beneficial. They can also be dangerous. And then open questions will also help the courts. You understand? Open questions will also help the courts, to determine the strength and weakness of a person's case. When a person is stating his case and trying to give evidence in favor of a party, the court will consider the weight of what he or she is saying. You understand? The court will consider the weight of what he's saying. We look at the strength and weakness of the person's case and evaluate it. And then open questions are also dangerous. You understand? They're also dangerous because when, for instance, you tell a witness, can you please tell the court what happened on the 15th day of August? What if that witness has forgotten? Or what if the witness is this kind of witness that talks too much? He will talk and even say what is not necessary. You understand? Or the witness will just go and be rambling, saying the same thing, using different words and all that. So open questions too can also be dangerous. It can also be dangerous. And then we also have another type of questions that may be asked in examination in chief. There's something called prodding question. You understand? Prodding question. Now, prodding question can also be asked in examination in chief. Example of prodding questions are questions that, just like the name implies, to prod. What does it mean to prod? To prod means to push, to facilitate something, to push something to go on. Prodding question. You're like, please go on. Yes, continue. Maybe Bukola will say something. Yes, go on, continue. These are examples of a prodding question. And then what happened? And then what happened after that? You're pushing the witness to go further. Don't stop in the length of evidence you're giving, to proceed and all. And then we also have incremental prompting questions. Now, these questions are asked to get specific details from a witness. When you want a witness to give a specific detail, about an issue or about a point, you use incremental or prompting questions. You understand? For instance, you can say, how far is your house from the scene? You understand? How far is your house from the scene? Like you want to know how far or you can say, please, how far is your room? Like the case of Bukola we are using. How far is your room from your room to the room of this your friend? That kind of thing. So incremental prompting questions seeks to get specific details. You understand? Specific details about issues. And then we also have first choice questions. First choice questions. Now, this type of questions helps to narrow the field of possible answers by suggesting specific options. Example of first choice questions are, for instance, when you finish shopping, did you return home or go somewhere else? You understand? Did you return home or go somewhere else? So it's just like first choice. You want to know which particular option the person took. Did you go here or did you go here? You understand? When your friend's roommate hit her with the iron, what did you do? Did you grab to stop her or did you stay on looking? Bukola, tell the court. You understand? It's a first choice question. You want to know the option she took. And then we also have introductory questions. Introductory questions are just like they are ordinary questions. It'll be like a witness. Please tell the court your name, address, and occupation. That is an example of introductory question. And then now we come to the most important one. This is the one you see in exam every time. Question 4. In the past 10 years, leading questions has been the subject of question 4 in criminal litigation, the compulsory question in section B. In the past 10 years, I think out of about 10 years, leading question has been the compulsory question in number 4. Let me say up to 7 times or 8 times. So that goes to show the weight that is attached to it. So now leading questions are questions that are suggestive of the answers expected by the questioner. You might ask yourself now, what is a leading question for us? But before we answer that, I want you to understand that ordinarily in examination in chief, you don't use leading questions. You understand? Ordinarily, when you are examining your witness in chief, you don't use leading questions. You understand? You don't use leading question because your witness that witness you called is supposed to state, he's supposed to state what he knows personally. You don't suggest an answer for the witness. Leading questions are questions that suggest an answer for the witness. You understand? So ordinarily, in examination in chief, leading questions are not allowed because a witness you called the witness to come and state what he knows. You understand? So the witness cannot come to court to state what he knows, and then you are suggesting an answer for the witness. Is not proper. You understand? But that is the general rule. There are instances when leading questions may be allowed, especially in examination in chief. Now, leading question may be allowed for introductory matters. Leading question may be allowed for facts that are undisputed. You understand? Leading question may be allowed for matters that have already been proven. Leading question may be allowed when you are addressing a hostile witness. Leading question may also be allowed when the court permits it. And leading question is also allowed during cross-examination. You understand? During cross-examination, leading question is also allowed. So we'll still come back to these exceptions. You understand that under these exceptions, sometimes you will see counsels asking witnesses leading questions during examination in chief. You understand? Under those exceptions. And then there are also instances when that leading question will not be allowed. That is when it does not fall under any of those exceptions. And the proper thing the defense counsel does is usually to raise objection. You understand? Because the question is leading, and the prosecution ought not to have asked that question because the circumstances asking the question does not fall within the exception when leading question will be allowed in an examination in chief. So now, leading questions are questions that are suggestive of the answer. You understand? So imagine for instance, okay, look at these 2 questions for instance. Now, look at these 2 questions. Witness, tell the court your name, your address, and what you do for a living. And then the witness says, I am Bukola Adeyemi, a student of the Nigerian Law School, Lagos campus. And then imagine this second question. Witness, you are Bukola Adeyemi, a student of the Nigerian Law School, Lagos campus. Am I correct? And then the witness says yes. Now, the first question is okay, but the second question is not okay. Why? Because the second question is suggesting the answer. You know, like the answer is already coming from the person answering it. You are Inspector Okafo Okon. Am I correct? The person says yes. You know, it doesn't make sense. You're supposed to allow the person to introduce himself. You are supposed to say, witness, tell the court your name. And then the person will not say, I am Inspector Okafo Okon. You don't suggest the answer for the person. So this is I'm just giving you an example of what a leading question looks like. You know, we'll still go to the sections and break it down one by one. And then like I said before, leading questions are generally not admissible in examination in chief unless when permitted by the court. You understand? So the court does not allow leading question during examination in chief. You know, it's not proper. A witness should come to court to state what he knows. You don't put words in the mouth of the witness. A lawyer should not put words in the mouth of the witness. And then we now give instances when the court may permit leading questions. Now, the court may permit leading questions for introductory matters. You know, now we are not talking about exceptions. Now, during examination in chief, now there are instances where leading questions will be allowed by the court. You understand? Now, one of them is during introductory matters. You understand? Introductory matters. And then I'm the one that added this. I opened the bracket. I added, if not in dispute. You understand? If not in dispute. It's very important. I will explain that later. So ordinarily for introductory matters, leading questions may be allowed. For instance, just like the example I gave, the example I gave about Bukola, that was a leading question, but it is allowed. The defense counsel cannot raise objection against it. For instance, I'm the prosecution counsel, and then Bukola steps into the witness box. I can be like, witness, you are Bukola Adeyemi, a student of the Nigerian Law School, Lagos campus. And then Bukola will say yes. Yeah, that is an introductory matter. Although from the nature of the question, it is a leading question, but because it has to do with an introductory matter, then it's going to be admissible. You understand? It's going to be admissible. And then for undisputed facts, although we'll still get back to that introductory matters, so we'll understand something there, but let's leave it first. And then for undisputed facts, now when certain facts are not disputed, you can ask leading questions on them. Why? Because those facts are settled, you understand? They are settled, they are not disputed, you understand? So for instance, now Bukola steps into the witness box, and then I'll be like, witness, you are the friend of the nominal complainant in this case, and you people have been friends for over 7 years now, since the university days. Am I correct? Yes. Now that fact is not disputed, you understand? Because ordinarily, yes, Bukola is a friend of the nominal complainant or the victim. Yeah, the fact is not disputed. You understand? That fact is not in any way disputed. You know, it's not in dispute. Nobody's concerned or arguing about whether Bukola is a friend of the nominal complainant or the victim. Nobody's arguing about that. It's not in dispute. So you can ask as much leading questions you want to ask on that matter. But ordinarily, the prosecution would have said, witness, please tell us a relationship with the nominal complainant. And then Bukola will now say, the nominal complainant has been my friend for the past 7 years. We attended the same university as well. But the prosecution went on to say, witness, you have been a close friend to the nominal complainant for 7 years now, and you people attended the same university. Am I correct? And Bukola says yes. It is okay. It is a leading question, yes, but because it relates to facts that are undisputed, nobody is disputing that. You understand? And then it's going to be admissible. So this is why it's very, very important. For me, in my own opinion, I would say the most important factor on when to raise objection against a leading question or when to raise an objection, for me, personally, the most important factor to determine when a leading question will not be admissible, to determine when a defense counsel should raise objection against a leading question, is whether that question that is being asked, that leading question that is being asked, relates to a matter that is disputed. So these disputed facts, is very, very important. The fact that the fact that a particular matter is disputed or not is very, very important. So imagine if, for instance, what is in dispute. Imagine if, for instance, now this Bucola's case is totally a different scenario. Imagine if, for instance, this Bucola's case is totally a different scenario. And then what is in dispute, what they're arguing about is whether or not Bukola has been friends with the nominal complainant for 7 years, or whether she has been friends with the nominal complainant for only 1 year. You understand? Maybe it is being disputed. It's part of the facting issue that the court wants to resolve. And then I see Bukola as a witness, and then I'm saying, witness, you have been friends with the nominal complainant for the past 7 years. Am I correct? The next thing you will just hear is objection, my lord. Now, why would the defense counsel object in that place, in that instance? Why? Because whether they have been friends for 7 years is part of the issues that brought everybody to court. Is being disputed. You understand? It's a facting issue. It's what the court wants to resolve. It's a material issue. You understand? It is actually a material issue. So the litmus test, the most important factor to know when a leading question will be improper or will be proper is to ask yourself, is this particular matter, is it disputed or not? If it's disputed, leading question will not be proper to be asked on it. So you can see why I opened the bracket and I added if not in dispute for introductory matters. Ordinarily, introductory matters, you can ask leading questions for introductory matters. But what if inside that your introductory matter, one of the matters they are disputed? Sometimes, for instance, now, the identity of a witness or the identity of a person or the address of a person might be in dispute. You understand? It is possible that the address of a person is in dispute or the identity of a person is in dispute. Maybe, for instance, the defendant now lives at number 139 NTA Road, Mboba, Port Harcourt. You understand? And then that place is being used as a haven. It's being used as a haven for drug trafficking. That particular address now is being used by the defendant and some of his cohorts as a haven for drug trafficking. And then police arrested one of his cohorts. You understand? Police arrested one of his cohorts who admitted to the crime, confessed to the crime. And then the defendant now is being charged in court. And then one of his cohorts has now been brought as a witness for the prosecution. And then one of the issues before the court, the defendant is saying that he does not live at number 139 NTA Road, Mboba, Port Harcourt. That place that the police raided, he has never been there before. He doesn't even know that place. That he has never been there before. He doesn't live there. You understand? That he does not live there. But then, why he's saying he does not live there, he's not disputing the fact that the witness that is in the witness box, he knows the witness, and they have lived together. You understand? The defendant, the main defendant who is being tried, is not disputing the fact. You understand? He's not disputing the fact that he knows the witness who is standing in the witness box, and they have lived together, let me say, in the past 1 year or in the past 2 years, that they have been living together. He's not disputing that fact. But he's just saying that he did not live together with the witness at number 139 NTA Road, Mboba, Port Harcourt. And then what if that witness comes to the witness box and then the prosecution is now saying, witness, you are Kelvin Okafor, who lives at number 139 NTA Road, Port Harcourt, Mboba. You understand? Immediately the defense counsel is going to shout, objection, my lord. Why? Because yes, that question relates to an introductory matter, but for the purpose of that proceeding, that his address, that particular introductory matter, his address is being disputed. Is being disputed. Understand? So because it's being disputed, because if ordinarily it is established that witness lives at number 139 Road, Port Harcourt, Mboba, automatically is implicating the defendant. You understand? Is implicating the defendant. So it's a matter in issue. It's part of the fact in issue that the court wants to resolve whether or not both of them actually lived at that particular place where the drugs and all those things were found. You understand? So whether or not a matter is disputed is very, very important. If a matter is disputed, you don't ask leading questions on those matters. The witness should on his own say what he knows. You understand? So I've just given you an example where an introductory matter might be disputed, and I used an address, for instance. Now, even a person's identity, a person's identity can be in dispute, and that is in relation to experts. Although we'll still get to that later. You understand? We'll still get to that later. That is in relation to expert. When an expert comes before the court. Now, let me just talk about this briefly. When an expert comes before the court, an expert such as a medical practitioner, a doctor, when a doctor comes before the court, and then that doctor prepared an autopsy report. You know the implication of an autopsy report. The autopsy report will show how you killed the person. Autopsy reports oftentimes provide evidence that yes, the defendant killed the victim. And then that medical doctor is with an autopsy report that the prosecution wants to tender through him. Oftentimes when all these experts like medical doctors come to court, before the court convicts on whatever evidence they are tendering, the court must be sure, that person is really an expert. The court must be sure that person, what does it mean to be an expert? Such person must have, a sufficient or substantial amount of qualification, experience, years of training in that particular field. So by the fact that an expert is coming before the court, and that autopsy report that he's holding will be a major determining factor whether or not the defendant will rot in jail for the rest of his life, by that very fact that the expert, the medical doctor is coming to court to tender that medical report, the identity, the qualification, the experience, the competence of that expert is already in issue. You understand? Is already a fact that is disputed. Why is it already a fact that is disputed? Oftentimes in criminal trials, once the prosecution has called an expert evidence like a medical doctor who has done everything he has done, blown all his grammar and all that, the defense counsel might sometimes cross-examine the expert. And one of the things you usually want to show the court is to show that person is not really an expert. That is one of the things that defense counsel does. They want to attack the qualification of that expert. They want to show that this person is not really a licensed medical doctor. He does not really possess the years of experience and qualification that he's claiming to have. You understand? He does not really possess the years of experience and the qualification he's claiming to have. That is what defense counsels often do in their cross-examination. Or if they don't attack the qualification of the person, they may attack his procedures. That, for instance, this autopsy report he conducted, he checked the liver first, he checked the kidney first, but in line with standard medical practice, he's supposed to check the brain first. His procedure is faulty. The experimentation is faulty. The hypothesis he drew is not correlating. They might also attack the procedure, but oftentimes they just go ahead to attack the qualification of the person. I know why I'm stressing this issue, because in your number 4, you must see these. You must see something like this. You understand? It's almost compulsory. You must see something like this. So whenever an expert is coming, a medical doctor is coming with a medical report that he's coming to tender, he wants the court to believe that medical report so that they will use it to convict the defendant. Then the qualification of that medical expert is already in issue. It's already been disputed, because immediately it gets to cross-examination, the defense counsel will most likely attack his qualification. You understand? So in that case now, since his qualification is already in issue, since it's a disputed matter, since it's a matter that is disputed, you understand? Since it is a matter that is disputed or that is likely to be disputed, the prosecution is not supposed to ask any leading question in relation to his qualification. Now, if, for instance, I called, maybe this is a murder case, for instance, the defendant is alleged to have murdered the victim. And then immediately after the murder, we conducted an autopsy report. Maybe sometime later, we conducted an autopsy report. One medical doctor conducted the autopsy report, and it simply shows that, yes, this was how the defendant was murdered. It must have been a grave machete wound. You understand? It must have been a grave machete wound. So in that case now, I'm calling the medical doctor as a witness. Now, ordinarily, this is the kind of question I'm supposed to ask the medical doctor. Witness, tell the court your name, your occupation, and where you live. Like, this question is very okay. This is an introductory matter. This question is very okay. It's very okay. You understand? So he will now be the one to tell the court, Kelvin Henry, a medical doctor of 30 years experience. I work with the University of Port Harcourt Teaching Hospital. Now, the witness on his own is establishing his qualification. You understand? The prosecution is not doing it for him. Now, imagine this second question. Uh, Witness, you are Kevin Henry, a medical doctor who works at University of Port Harcourt Teaching Hospital. Now, this question is leading, but it's not objectionable. It's a leading question, but it's also okay. Like, it's leading, but it can pass. It can pass under the exception, introductory matters, that he's a medical doctor and he works at University of Port Harcourt. There's no problem with that. But now, imagine this third question. Now, look at this third question. Witness, you are Kelvin Henry, a distinguished medical doctor, a distinguished medical doctor with over 40 years of experience. Am I correct? And then the medical doctor will say yes. Now, what do you understand by this third question? This third question is not only leading, but it is touching upon a matter that is disputed. You understand? It would have been saved under the exception that it relates to introductory matters, but the prosecution has asked the question on what is disputed or what is likely to be disputed. What is that? The qualification of the expert. He went on to say that he's a distinguished expert and he has over 50 years of experience. That's not necessary. It's the expert that will do it himself, not you, the prosecution. Understand? Not you, the prosecution. You are not the one who is going to do it. So whether or not a matter is disputed is very, very fundamental. For me, I think that is the major determinant of when a leading question is going to be proper or improper. So we might ask ourselves, why are leading questions objectionable? Like, why do defense counsels object to leading questions? Leading questions are objectionable because they intend to influence a witness on what to say. You understand? It is also a way of tutoring a witness to say a particular thing. They tend to distort the truth. They are not fair. Leading questions are also not fair because ordinarily, when you call a witness, that witness is supposed to say only what he knows. You don't put words inside of the mouth of that witness. And then we look at experts and leading questions. So just like what I've been explaining, experts are not permitted to be asked leading introductory questions tending to establish their qualifications. Where same is an issue. He must establish them himself. So this is just like what I've been saying. When you call an expert, for instance, a medical doctor, you don't ask him introductory questions that are leading in respect of matters which are disputed, especially when it relates to his qualification. Oftentimes, when an expert is called, his qualification is already in issue. Understand? Immediately you call an expert and you want the expert to say something or tender any document that the court will believe and convict the defendant, the qualification of that expert is automatically in issue. It is in dispute. You understand? It is in dispute because immediately you are done, the cross-examination will usually center on his qualification. The defense counsel will want to show the court that this person is not really qualified. You understand? He's not, whatever he did in the autopsy report is nonsense, that kind of thing. And then it's relevant to note that if an expert is given an evidence, if you call an expert witness, maybe a medical doctor, he should give evidence only on his area of expertise. You understand? Expert evidence must be tied to his area of expertise. So if, for instance, you call an expert a medical doctor, he is required to give evidence only on that his medical practice. You understand? So a medical doctor cannot jump from his medical practice and enter the type of gun that was used. So if, for instance, he conducted an autopsy report and he found out that what killed the victim or what killed the deceased was a bullet wound, and then he saw the bullet, he brought out the bullet, that's enough. You understand? That's enough. You understand? He should not go on to say that they make the type of the bullet is a M16 or is a AK-47 or the bullet was produced in Russia or it's not his area of expertise. That is for ballistic experts. You understand? So whenever a person calls an expert witness, and that expert witness leaves his area of expertise and begins to give evidence on areas which he's not an expert, the implication is that such evidence is no longer characterized as is no longer called an expert evidence. It is now referred to as opinion evidence. You understand? It's not referred to. It's now giving an opinion evidence, and in that case, you know the effect of an opinion evidence when it's not given. When an opinion evidence is given by a person who is not an expert, such an evidence must be discarded. You understand? Measures against them, such an evidence must be discarded. And then we go to cross-examination. Cross-examination. Like I told you, immediately after the examination in chief, the next thing that follows, if that is the only witness that the prosecution is calling, the next thing that follows is the cross-examination of that witness. You understand? So that witness will usually be cross-examined by the defense counsel, and we know the purpose of that cross-examination to show that he has made a contradictory statement, to water down the effect of whatever the witness said in examination in chief and all that. And then it's relevant to know there's this saying that the sky, there's this saying that they say the sky is the limit of counsel in cross-examination. Therefore, in cross-examining a witness, the counsel can ask any kind of question he likes. He can ask the witness any question relating to any matter at all. That is not true. You understand? That's not true. The sky is not the limit. The sky is not the limit. The sky is not the limit. The sky is not the limit of a counsel in a cross-examination. You understand? A counsel must tie his questions to facts which are relevant. You understand? The question a counsel is asking a witness must be relevant to the fact in issue. Understand? Even if it's not tied to what the witness said in his examination in chief, it must be relevant to the fact in issue. So we cannot, for instance, I, the prosecution, cannot call a witness who is testifying on a particular matter, and then during cross-examination, the defense counsel will now come and say, "This witness, are you not the same person who have married up to 7 times? You keep moving from one husband to the other. How is that related to the fact in issue? You understand? So you don't come and ask anyhow questions. You don't come and start asking. You don't come and start asking stupid questions. You don't come and start asking stupid questions. You don't come and asking questions that are stupid. So we might ask ourselves, what is the effect of failing to cross-examine a witness? What is the effect when a counsel fails to cross-examine a witness? It is relevant to know that cross-examination is not compulsory. If, for instance, the prosecution has called his witness and have examined his witness in chief, it's not compulsory that you, as a defense counsel, must cross-examine such a witness. You understand? You should only cross-examine a witness when you feel it's proper. You understand? But then it's relevant to note that if you fail to cross-examine a witness, everything the witness said in the examination in chief is deemed admitted. Yes, you are deemed to have admitted everything the witness said in the examination in chief. You are deemed to have admitted it. And then purpose of cross-examination. Of course, we know this. To ascertain the accuracy, the veracity or credibility of the witness, to uncover the identity of the witness and position in life, to shake the witness credit by injuring his character, to contradict the witness's testimony and weaken the evidence of the party calling him, to present the opposing party's case, to extract favorable facts for the opposing party, and to gather facts for cross-examining other witnesses. Now, when we talk about these, to shake the witness credit by injuring his character, I gave you an example where the person was talking about how he has married up to 7 husbands. Now, that is not a perfect example for this. That is not a perfect example. Because you want to injure the witness character doesn't mean you'll be talking rubbish that does not relate to the facts which are relevant in the case. An example of shaking a witness credit by injuring his character is, for instance, I gave you an example where during the cross-examination of Bukola, the lawyer was like, but you said this your phone was irredeemably bad, and now you are saying you use the same phone to take pictures. The lawyer will be like, I put it to you, Bukola, that you are not a witness of truth, and you are trying to mislead this court, that is an example. That's an example. So you are trying to show that Bukola does not have a good character. You're trying to show that Bukola does not have a good character by trying to mislead the court. So now in cross-examination, what are the kind of questions that you might ask in cross-examination? In cross-examination, there are about 4 types of questions that you can ask. Now you can ask the closed question. Closed questions are like the opposite of open questions. During your cross-examination, you never dare to ask a witness to explain. That's improper. When you do your professional ethics and skills, you notice that we have 10 commandments of cross-examination. So there are some questions that you must not ask a witness. You don't ask a witness to explain. You have to compress. You have to compress the question. You have to compress the question. So you have to use closed question instead of open question. In this case, now in cross-examination, it is no longer your witness. You are cross-examining somebody's witness, and then you want to contradict that witness. You want to show that the witness is not a witness of truth. So you don't require the witness to explain. You don't ask the witness open question. In cross-examination, you cannot be saying, Bukola, what happened on that day? No, you can't be doing that. That is an open question. It's not. You don't do that. If you give her that opportunity, she will even correct her mistakes during the examination. So what you use is closed question that require yes or no. On that day, did you do this or you didn't do it? Yes or no, and the witness will answer. You understand? Then you can also use confrontational questions. Confrontational questions. That is questions that tend to challenge the witness testimony. And then in cross-examination, you can use leading questions. You can use leading questions in cross-examinations. Remember one of the exceptions when leading questions are allowed is during cross-examination. And then you can also use probing questions. That is questions intended to show that the witness is not a witness of truth. You can use probing questions as well. And then there are some questions that are prohibited during cross-examination. There are some questions that are prohibited. You don't ask indecent or scandalous questions unless they relate to matters in issue or fact which are necessary to establish such matters. You don't ask questions that are insulting, questions that are annoying. You understand? Even if such questions appear proper, you don't ask them. And then you don't also ask irrelevant questions. You don't also ask questions that are irrelevant. Somebody call a witness, and then instead of you to attack matters that are in issue, you are saying, are you not the same person who has married up to seven husbands? How is that related to the fact in issue? Such a question is irrelevant. It's not such a question is not proper. Such a question is not proper. And then that when a counsel, you as a lawyer, when you go ahead and you're asking stupid questions, you're asking a witness irrelevant, scandalous, indecent questions, there's a punishment for you. The court can just report you to the Attorney General of the Federation, for disciplinary actions. Although this one exists only in paper. Who has that time? Even the AG will not even have the time. And then now, what if there are multiple defendants? How do we do cross-examination where there are multiple defendants? So let's take for example, say where there are co-defendants. Whenever you hear the word co-defendant, think of where 2 or 3 persons are charged together for an offense. So whenever there are co-defendants, they say each defendant has right to cross-examine each prosecution witness before the prosecution re-examine his witness. You understand? So where there are co-defendants, where we have defendant A, defendant B, defendant C, 3 persons are being charged for an offense. If prosecution conducts examination in chief, if the prosecution conducts examination in chief on his witness, you understand? If the prosecution conducts examination in chief on his witness, now the prosecution will not just immediately go on and conduct re-examination. Before he conducts re-examination, there must be cross-examination. And in this case, A, through his counsel. For instance, if they have 3 different counsels, A, through his counsel, we have to cross-examine prosecution witness. After he's done, B, through his counsel, we have to also cross-examine that same prosecution witness. And then C, lastly, through his own counsel, we also cross-examine that prosecution witness. After the 3 of them have cross-examined the prosecution witness, then the prosecution can now conduct a re-examination on that his witness. And then, if for instance now those co-defendants A, B, C, one person inside of them calls a witness, just one person inside of those co-defendants calls a witness to defend him, calls a witness to state an evidence in his favor. You understand? Now, each co-defendant, that is B and C, if, for instance, it is only A that called a witness in his own case, three persons are charged together, A, B, C. But now only A, one defendant, called a witness for himself. You understand? He called a witness for himself. Now, before the prosecution will cross-examine that witness called by A, B and C, who are co-defendants, B and C, who are co-defendants, must cross-examine that his witness first. Understand? Now, the purpose of this is to avoid inconsistent evidence, to avoid to make sure that their case is consistent. This is just like a fair hearing. This is more like a fair hearing. This is more like a fair hearing. So if A calls a witness, before the prosecution will cross-examine that witness, understand? B and C must have to cross-examine that witness first, understand? Before the prosecution can then cross-examine the witness. And then, like we said, we also have the third stage of examination, which is the re-examination. Now, re-examination has two main purposes, and the purpose of re-examination is to clarify issues raised during cross-examination and to address any ambiguities from a cross-examination. Re-examination is done by that person who called the witness. Yes, and re-examination is done by that person who called the witness. Like the example I gave you with Bukola and the prosecution. So now, what is the right of the opposition where new evidence is introduced during re-examination of a witness? Now, remember that during re-examination, you are not allowed to introduce a new matter. During re-examination, it has only two purposes. There are only two functions. We only have two functions of re-examination. If there's any ambiguity, clarify it. If there's any inconsistency, address that inconsistency. Rectify that inconsistency. Clarify any issues. Address any ambiguity. Clarify any issues, any inconsistencies that are raised during the cross-examination. That is what you do in your re-examination. You don't come in your re-examination and then you want to tender a document, or you want to give new evidence, or you want to introduce a new matter. Understand? If a person does that, usually it is with the leave of the court. You understand? If a person does that during his re-examination, maybe usually it is with the leave of the court, and then where he does that with the leave of the court, the opposition, the defense will now be entitled to cross-examine. You understand? The opposition, the defense will now be entitled to cross-examine on that particular matter. You understand? So if for instance, now the prosecution during his re-examination tendered another document through his witness, you understand? Now the defense counsel will be entitled to cross-examine the witness on that document. You understand? On that document. You have to cross-examine the witness on that document. And then witnesses oftentimes you can in a criminal trial you can subpoena a person to come and testify, subpoena ad testificandum. You can also subpoena a person to come and tender documents alone, subpoena ducis tecum. You understand? So you can also so there are different kinds of subpoena. We saw that in the last class. Understand? So you can subpoena a person to come and testify for you. You can also subpoena a person to come and tender document, and you can also subpoena a person to come and do both for you. Understand? So what if, for instance, a person is only subpoenaed to come and tender a document? For instance, a banker, understand? By the order of the court, you called a banker to come and tender maybe a statement of account or something. Understand? Now, what that banker is supposed to just do is to come to court and tender that document and go. That banker has not become a witness subject to cross-examination. Understand? Maybe prosecution just subpoenas a banker that is working at a First Bank. He say, come and tender the statement of account. And then through the banker, he tenders the statement of account. Now, that banker will just go. He just came to tender a document. He's not a witness that will be cross-examined. You understand? That is what this principle is saying, Section 219 of the Evidence Act. You understand? He cannot be cross-examined as a witness. He just came to tender a document. He has tendered that document. He will have to go. Understand? Your duty as a defense counsel is to, you have to now maybe attack the authenticity of the document, but it's not for you to cross-examine who tendered. He might even have been just delegated to just tender that document in court. You understand? He might even have been delegated. So he does not become a witness that will be cross-examined until he has been summoned as a witness. You understand? Until he has been summoned as a witness. And then during the examination of witnesses, whether during examination in chief, cross-examination, or during a re-examination, it's relevant to know that the court has powers. The court has powers. The court can decide to put questions across to the witness. The court can even tell a witness not to answer a particular question. Remember, maybe the court can say, don't answer this question. It's irrelevant. So the court has power. The court may also put questions across the witness to clarify issues. The court can also require a witness. On their own, the court can require a witness to produce any documents that is believed to be in his possession. And then that's what we call power to recall a witness. So what if a witness has come and then the witness has testified for you and the witness has left? You understand? So is it possible for that witness to be recalled? It's possible. The court can on their own recall a witness. The court can on their own recall a witness. The court can call back a witness if they believe that witness have to come and say something again. Maybe there was what that witness was saying and they didn't get it properly. But now it has appeared that it is very, very important that the witness should come and restate that particular thing, because that particular thing is now like the core issue that, if resolved, will lead to a decision. And the court can call back the witness. It is usually done in the interest of justice. But if such witness is recalled by the court, that person is the witness of the court. Understand? It's not a witness of any party again. So no party will want to come and say, I want to cross-examine him. Or the other party will say, can I just re-examine him again? No. If you want to do that, you have to seek the leave of the court. And then apart from the court calling back a witness, the party as well, the defendant, that's the defense or the prosecution can also seek the leave of the court to recall a witness. Understand? They can seek the leave of the court to recall a witness. It is also possible.